There was a phone on the evidence table, pink case, cracked at one corner, a blue whale sticker peeling off the back. It belonged to a 9-year-old girl, and by the time I finished that case, I understood that the smallest object in the room had carried the heaviest truth. I still think about that phone more than I think about the black SUV, the crosswalk paint, or the man at the defense table whose watch cost more than some families live on for months. I think about it because when that phone lit up, the case everyone thought they understood turned into the case I actually had to decide. Before I go further, I need you to subscribe, not as a formality, because there is one piece of evidence in this case, something small, something easy to miss, that changed the direction of my ruling. I want to make sure you are here when I get to it. Subscribe now. The file first came to me on October 3rd, 2025. I remember the date because it was a Friday, and my clerk had already warned me there would be media in the hall by noon. When I saw the defendant's name clipped to the top page, I understood why. Adrian Mercer, 47 years old, founder of Mercer Vale Systems, billionaire, public donor, regular subject of magazine profiles that used words like disciplined and visionary. None of that mattered from my bench. What mattered was what happened on September 14, 2025, at 3:42 p.m. outside Willow Creek Elementary School in Redwood City, California. The woman who had been hit was Rosa Alvarez, 34, crossing guard during the week, home health aide on weekends. When she first entered my courtroom, she used a cane in her right hand and a folder under her left arm. But what I noticed was not the cane. She stopped before sitting down and straightened her daughter's collar with two careful fingers, as if the room could wait until that one small thing was right. When Rosa testified, she did not speak like someone asking for sympathy. She spoke like someone still trying to do her job. She said, "I had already seen the children step onto the curb behind me, so I raised my hand higher." I wrote that down, not because it was dramatic, because it told me exactly where her mind was in the second before impact. Her daughter was Sofia Alvarez, 9 years old, 3rd grade, shoes that flashed blue when she moved too fast. She sat beside her mother with a notebook on her lap and kept writing down words the adults used. At one break, I saw her lean over and ask her mother how to spell objection. Rosa whispered it to her like it was a normal thing for a child to need. Adrian Mercer came into court the way men like him often do. Not loud, not careless, measured. He kept his shoulders loose, his expression controlled, and his hands still unless he thought no one was looking. Then he would adjust a cuff, line up the papers in front of him, or touch the knot of his tie as if the day might yet bend back into shape if everything around him stayed in order. I watched him when nothing important seemed to be happening. Those are useful moments. During recess, while his lawyers spoke to reporters at the back, he looked first toward the cameras, then toward his chief of staff, Lena Pritchard, and only after that, toward Rosa Alvarez. He looked at Rosa the way some people look at a roadblock, not a person, a delay. He waved a jury, that was his right, so the facts would be decided by me alone. People sometimes think that means a defendant wants calm instead of emotion. Sometimes that is true. Sometimes it means they believe a judge will be less moved by what injury looks like once it enters a room. There is a part of the process most people never see. Before I allowed Sofia to testify, I had to decide whether she understood the difference between truth, a lie, and a guess. That is not about age alone. It is about whether a child knows that truth stays the same even when fear enters it. I asked Sofia what happens when someone guesses. She said, "Then the story changes when you ask again." I asked what happens when someone tells the truth. She said, "It stays the same even if they are scared." I remember looking down at my notes for a second after that, not because I doubted her, because I did not. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. Tell the stories that need to be told. By the time trial began, I knew the incident in pieces. That is how I always know these things. Not by seeing them myself, but by reading reports, hearing testimony, and sitting with so many versions of the same few seconds that they start to settle into one shape. At 3:42 p.m. on September 14th, Adrian Mercer was driving a black 2024 Mercedes-Maybach GLS 600 westbound on Alder Street. School dismissal had started 12 minutes earlier. The school zone speed limit was 15 miles per hour. Parents were double parked. Children were crossing in clusters. Rosa Alvarez stepped into the marked crosswalk wearing a fluorescent yellow safety vest and raised her left hand toward traffic. Adrian Mercer moved around a stopped pickup truck and entered the crosswalk area at just over 26 miles per hour. His SUV struck Rosa with the front right corner, her pelvis fractured. Her right knee was badly damaged. She fell hard onto the painted lines she was standing on to protect children. One witness, Neil Dorsey, had been sitting across the street in a silver minivan. He said he heard a horn, then a shout, then the sound of impact. He said Mercer got out and said, "I did not even see her." That quote came into evidence early, and it remained there through the end. Another witness said Mercer also said, "Call someone, we need to handle this now." On paper, that could sound like urgency. In court, words depend on what surrounds them, who they were said to, what had already happened, what was said next. The first wave of evidence was simple. The SUV was his. He was driving. The crossing was clearly marked. The school zone signs were visible. The event data recorder showed braking less than a second before impact. The traffic investigator testified that Rosa was 11.8 feet into the crosswalk when she was hit, and that the driver had a clear line of sight for at least 3.1 seconds. While that investigator testified, I watched Lena Pritchard behind the defense table. She had a gold pen in her hand and had been tapping it lightly against a notepad. When the witness said, "Clear line of sight," the tapping stopped. She did not write anything. She just looked at Adrian Mercer, and he kept looking straight ahead. The paramedic who treated Rosa said her first concern was not herself. It was whether the children behind her had seen the collision. He also said Mercer stayed at the scene, called 911, and tried to come closer until emergency staff told him to back away. That mattered. I do not throw away facts because they make a case less neat. The defense relied on those facts. They said Mercer panicked, but he did not run. They said he called for help. They said he stayed near the victim. They played the 911 call. His voice sounded strained. He said, "There's been an accident outside Willow Creek. A woman has been hit. Please hurry." Rosa did not dispute any of that. When her lawyer asked whether Mercer came toward her after impact, she said, "Yes." When asked whether he called 911, she said, "Yes." Then she looked at him across the room and said, he saw me after. I wrote that down too, so by the end of the second day, most people in that courtroom believed the shape of the case was set. A rich man drove too fast in a school zone, hit a crossing guard, stopped, helped, panicked, and would argue that panic should matter. That was the story almost everyone had settled on. I have told this story before, to colleagues, to my family once, and every time I get to this part, I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it. The third day changed the case. We were arguing over a photo issue just before lunch when I heard a small voice from the gallery say, "I have proof." I looked down. Sofia Alvarez was standing beside her mother, holding that pink phone in both hands. Her mother reached toward her, but Sofia was already speaking. She said, "I know he stopped. I know because I filmed it." The room went still. Then every lawyer in it stood up at once. We recessed immediately. The phone was secured. A forensic image was made. Both sides were heard on admissibility. The file had not been turned over earlier because Sofia had forgotten it existed. She mostly used that phone for games, photos, and messages to cousins. 2 nights before, while clearing storage, she found the video. I admitted it. Not because it came from a child, not because it favored one side. I admitted it because it was relevant, authentic, and too important to leave out. The clip was 47 seconds long. It began low, shaky, pointed at pavement and shoes. Then it lifted. Rosa was on the ground. A child was crying off camera. Adrian Mercer was there without his jacket, one knee bent, face pale. He said, "Ma'am, stay with me." That supported the defense. Sofia had been right. He had stopped. Then Lena Pritchard stepped into frame. Mercer turned his head toward her and said, "Tell them Elias was driving." She froze. Then he said, "He wears the cap half the time anyway." The clip ended seconds later. I asked the court reporter to read the line back exactly. She did. The words did not change. I watched Mercer while that video played. For the first few seconds, he seemed almost relieved. Then his own voice reached that line, and he touched his tie knot once, hard, like it had tightened around his throat. Sophia testified after the video. I kept my questions plain. I asked why she had recorded. She said, "Because my mom was on the ground and nobody would remember it right." I asked why she brought the video in now. She said, "Because people kept saying he left and he did not, but he said another bad thing too." That was the third wave of evidence. The first wave told me he hit Rosa. The second told me he stayed. The third told me what kind of man he was in the minute after he understood what he had done. The defense argued fairly. They said the audio was not perfect. They said Mercer might have been confused. They said Elias referred to his driver, who often used the same vehicle. They said panic scrambles language. I listened. None of those points were foolish. None solved the problem. Mercer then took the stand himself. Some defendants should not do that. Some must. He chose to. At first he was polished. He said he had glanced at a message about an overseas supply failure. He said it was less than a second. He said, "I did not see her. If I had seen her, this would not have happened." Quiet voice. Still wrong. Under cross-examination, he was asked about the video. He said, "In moments like that, words come out badly." Then he said, "I was trying to keep my company from taking a false public hit while we still did not know the facts." I wrote that down. He meant to defend himself. He told me something truer instead. Later, trying to show character, he said, "I fund trauma wards and scholarship programs. I am not the kind of man who leaves people on the ground." That sentence stayed with me too. It was meant to sound decent. What I heard in it was a man trying to use past generosity as credit against present conduct. Another witness, Marisol Green, testified that just after the collision, she heard Mercer say, "I cannot be stuck here all afternoon. Move the car." The defense challenged that account, and I gave that challenge full weight. But I heard the line. I kept it where it belonged, among the other facts that showed me how he thought when control began to slip. Subscribe if this is the kind of story you want more of. That is the whole pitch. No speech. Just subscribe if it is for you. There was a moment during his testimony when my mind went back to a memory I do not usually speak about. I was 8 years old, standing outside my own school in Fresno, holding a paper lunch sack my mother had brought me because I had forgotten it that morning. The crossing guard had his hand up. One driver rolled forward anyway, not enough to hit anyone, just enough to make every child at that curb take the same half-step back at once. I remember my mother's hand landing on my shoulder, not hard, just there. I do not remember the car. I remember the half-step. I never mentioned that in court. It was not evidence, but some cases connect to a place inside you before the ruling is spoken, and pretending otherwise would not be honest. When the evidence closed, I requested briefing on two narrow issues: whether his post-impact conduct reduced culpability, and whether the video showed a deliberate attempt to shift blame. I read both sides carefully. I made my findings in writing. By the time I walked into court to rule, I had already made my decision. The room was full that morning. Rosa Alvarez sat with both hands wrapped around a folded tissue she never used. Sophia sat beside her, feet not reaching the floor. Adrian Mercer sat at the defense table with a yellow legal pad in front of him that remained blank the entire hearing. I found Adrian Mercer guilty of felony reckless driving causing serious bodily injury. I found him guilty of unlawful handheld device use in an active school safety zone. I found him guilty of making a false statement in the immediate aftermath of the collision. I acquitted him on the allegation that he fled the scene. Sophia had told the truth about that, and I said so from the bench. The first reaction I noticed was not his. It was Lena Pritchard's. She closed her eyes and let out one slow breath like she had been holding it since that video played. Then Sophia turned toward her mother, and Rosa put a hand at the back of her daughter's head. The verdict was not the hardest part of this case for me. The sentencing was, because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. I set sentencing for 3 weeks later so the parties could submit restitution figures and medical updates. That hearing gave me numbers, treatment plans, wage records, counseling estimates, and housing concerns. Rosa's injuries had forced one surgery already, with another scheduled. She had missed 14 weeks of work. The stairs to her apartment had become a daily problem. When I sentenced Adrian Mercer, I spoke slowly. I wanted every word heard the first time. I said, "Mr. Mercer, I am placing you on formal probation for 5 years, and I am suspending execution of an 18-month county jail sentence on the condition that you comply fully with every order I'm about to make. If you fail, that sentence will be imposed." I said, "I am ordering you to pay a fine of $5 million to the California School Crossing Safety Trust. I am doing that because this was not a private mistake in a private place. It happened in a school zone, at dismissal, where children were taught to trust the signs, the paint, and the raised hand in front of them." I said, "I am also suspending your California driving privilege for 8 years, with no restricted license of any kind for the first 4 years. You will not drive personal vehicles, company vehicles, or borrowed vehicles. I am doing that because you treated driving as part of your urgency, and the law requires me to separate you from that privilege." I said, "I am ordering 1,200 hours of in-person community service at San Mateo Rehabilitation Center and in county school zone safety programs, no donations in place of service, no staff substitutes. I am doing that because injury should not remain an idea to you. You need to spend time where recovery is slow and cannot be handed off." I said, "I am ordering full restitution to Rosa Alvarez, including both surgeries, physical therapy, lost wages, transportation, trauma counseling for Rosa Alvarez and Sofia Alvarez, and the cost of accessible housing for 18 months. I am doing that because the person you hit should not have to rebuild her life through debt." Then I said, "And there is one more thing. Within 30 days, you will stand at Willow Creek Elementary at a public safety meeting and read a written statement aloud. It will be 1,200 words. It will contain no branding, no legal hedging, no reference to your charitable history, and no use of the phrase, 'if anyone was hurt.' It will say exactly what you did, exactly where you lied, and exactly who carried the cost." I added one last condition. I said, "You will fund, without naming rights, raised crosswalk beacons at Willow Creek Elementary and 2 nearby schools chosen by county injury data. Your name will not appear on a plaque. I am doing that because repair is not an advertisement." Then I looked directly at him and said what I needed to say. I said, "You did not just strike Rosa Alvarez with a car. You took away her steady walk for months, her income for a season, and her daughter's belief that a bright vest and an open hand could stop a man in a hurry." I said, "Your family did not choose what you did that afternoon, and they are not on trial for your failure." I said, "Privilege does not reduce duty, it increases it." And then I said, "I believe you knew the truth quickly, and I believe you tried to place it on someone smaller than yourself. Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here." After sentencing, the courtroom did not empty all at once. It loosened in small pieces. Reporters moved first. Lawyers gathered files. A deputy opened the side gate. What I remember most is Rosa turning toward Sofia and lowering herself as carefully as she could. Sofia was crying by then. Rosa held her face and said, "You did what I asked. You told the truth." Adrian Mercer stood, buttoned his jacket, then unbuttoned it again. He leaned toward one of his lawyers and said quietly, but not quietly enough, "This did not have to become this." I heard it from the bench. I said nothing. As the room thinned out, Sofia went to the evidence clerk and asked whether she could have her phone back now. The clerk handed it to her. Sofia looked at the cracked case for a second, then slid it into her backpack and reached for her mother's cane with her other hand. That was what the room felt like when I finally stood up, not loud, exact. The appeal went to the California Court of Appeals, 6th Appellate District. The defense challenged the admission of Sofia's video, the false statement finding, and the public reading condition of probation. 11 months later, the convictions and sentence were affirmed in full. The appellate court said the video was properly authenticated, the record supported deliberate deception, and the probation terms were directly tied to accountability and repair. I was not surprised, but I was relieved. I learned what happened later in pieces, as I usually do. On June 18, 2026, the county held an event for the first raised beacon installation at Willow Creek. I attended. Rosa Alvarez was there in flat shoes, walking slowly but without her cane. Sophia crossed the new raised crosswalk twice just because she could. Adrian Mercer was there too. No cameras near him, no speech from him. He wore a plain blue shirt and carried folded safety pamphlets from one table to another because that was the assignment his service supervisor had given him. At one point, Sophia dropped a stack of paper wristbands. He bent down, picked them up, set them on the table between them, and stepped back. I noticed that. I leave the rest to you. The question this case left me with is not whether he was guilty. I answered that. The question is what we do with a person who does one decent thing in the middle of doing a harmful one. He stopped. He tried to help. He also lied when the truth first became expensive, which fact tells you who he is. I still do not know if one answer covers every case. What I do know is that I have seen people with very little tell the truth even when it gave them nothing back. And I have seen people with every advantage begin arranging the story the moment plain facts threaten the version of themselves they prefer. If you are someone who has felt what Rosa felt when she said, "He saw me after," then you know the look I mean. The moment when the person who hurt you is already building a story that leaves less room for your reality inside it. If that is familiar to you, I want you to hear this from me. I noticed it. I believed it when I saw it. And I know what it costs to keep speaking anyway. And if you are closer to Adrian Mercer than to Rosa Alvarez, if your life is built around access, speed, assistance, gates, and people who smooth out your delays, then I have one question I wanted to ask more directly than the bench allows. When was the last time your convenience mattered less to you than another person's safety in the exact second that choice had to be made? If you do not know, start there, put the phone away, arrive later, let the line wait. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. I told you at the start about a phone. Pink case, cracked corner, blue whale sticker peeling away. A child's phone in an adult courtroom. For 3 days, almost everyone in that room believed the truth would come from the people with titles, fees, and trained voices. In the end, it came from a 9-year-old who understood that if she did not keep the record, adults might bend it. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments are where people who care about the same things find each other.